And so the question is raised as to whether he can force the delivery of the commission, or whether the decision to deliver or not deliver the commission, in other words, the decision to appoint or not appoint a justice, is discretionary with the executive branch.
So this decision ends up cementing the power of judicial review? Is that
well, it does, but in an artful manner. The case comes up to the Supreme Court, and there really are three issues. The first issue is whether, when Adams signed the commission, did that vest a right in all the people who were the holders of the offices to that office. The second is whether the executive branch can change that because they have discretion. And the third is whether the Supreme Court is actually entitled to hear the case. And it's the last part that Marshall cleverly converts into the principle of judicial review.
So in terms of judicial history, Professor, how does this decision and the decisions of the Marshall Court affect the focus of subsequent Supreme Courts? How does that change the manner in which the law is worked on?
Well, it's an absolutely vital decision, although it's not fully understood as that at the time. It appears that, to the extent there was a theory of constitutional interpretation by the various branches of government that informed the framers of the Constitution, it was that, yes, the Constitution needed to be interpreted, but it wasn't clear that the judiciary was the sole or even the dominant interpreter. The theory seems to have been something like all branches of government are equally entitled to interpret the Constitution. And the question is whether this is an area within the province of those branches or not. And so the argument of the Jefferson administration in Marbury is the decision to appoint an officer is in the discretion of the executive branch, and so their interpretation ought to control. What Marshall does in Marbury is say, no, if this is a case and controversy, as the Constitution prescribes in Article 3, then the judiciary has the power to interpret the meaning of the Constitution within that. And so even though he ends up saying eventually that the Supreme Court can't hear this case, he claims the power to interpret the Constitution to decide whether it can't hear this.
I wish we had time today, because our time is short, to look at the different courts and how it developed. But this case is so central, I think it's worth focusing there. How does a court, Professor, guard against ideology being a factor of decision making? In the last chapter of your book, The Marshall Court on Cultural Change, you discuss this sort of dance, the nuances of change versus permanence and maintaining revolutionary principles, and therefore flexibility, and at the same time keeping stability.
Well, there are really two issues raised by what you said. The first is the question of to what extent ideology plays a role in judicial decision making. The second is whether, in interpreting the Constitution, judges should emphasize stability or change or both. First of all, I mean, unquestionably, judges are human beings, and judges have ideological presuppositions, and those are to some extent bound to affect the decisions they make. But the role of judge emphasizes constraints on the ability of judges to impose their political or social views on the Constitution. So even where judges begin the exercise of interpreting the Constitution with ideological presuppositions, they're constrained from saying openly, I am advancing this interpretation of the Constitution because it accords with my ideology. They have to look at other sorts of sources. Now, with respect to stability and change, the Constitution, as Marshall put it in a case, was designed to be a document that endured over time. The idea is that the provisions are sketching out broad principles, but the principles are going to be interpreted in new cases as they arise. So the question is always, when you get a new controversy involving issues that the framers may not have anticipated, and you have a constitutional provision, what should be the controlling guideline? Should we look back to the original intent and understanding of the provision of the framers, in which case we run the risk of having constitutional interpretations frozen in time?
Well, I know from looking at your book that one of the things that Marshall believed in was judicial discretion, but his idea of discretion was, as you say, guided by founding principles. It was not simply a strong political will on his part.
He calls it at one point, he talks about judicial discretion. He says it's a mere legal discretion.
Yes.
And what he means by that is that there's an obligation on the part of the judiciary to follow controlling legal principles. And by discretion, what he means is judges have a range of interpretation of existing principles. They can help explain what they mean as applied to continuing cases. But other than that, they don't have discretion to substitute, as he puts it, their will for that of the law.
Now, how do you... Presidents appoint justices, and presidents have party loyalties, points of view. So how do you guard? I mean, for instance, the last few courts in our history, the Burger Court, the Rehnquist Court, now the Roberts Court, are perceived as having particular ideological, they're ideologically driven. So, and they at times appear to be. So would you say that the present court, for instance, let's just take the Roberts Court, would you say that that court strives for discretion within the range that Marshall outlined, that is to adhere to the original constitutional principles, to keep political opinion out of it? Or would you say over time the courts, and particularly looking at our court now, has drifted in one direction or the other?
Well, as to the question of how much stability or how much change counts, individual justices on the Roberts Court differ on that.
Right.
And Justice Breyer is an advocate of what's called living constitution theory, which is the idea that the Constitution needlessly has to change over time because you get new social and political contexts in which you make interpretations. You know, Justice Thomas is of a different view. He's an originalist. That is, he thinks that what should be controlling is the interpretations of the framers. But I would not say that the Roberts Court or the Warren Court are compelled by ideology in the way we would think of, let's say, political candidates as being. I think an important thing to emphasize is that all justices of the Supreme Court have to deal with precedent, have to deal with the text of the Constitution, and they can't. It's just not open season for them to impose their ideologies.
Jefferson stated on the eve of Marbury versus Madison that we are all Republicans, we are all Federalists. In their book, The Great Decision, authors Sloan and McKean note that in addition to their connections with one another to the cases, most of the key players, Marshall, Marbury, Madison, and Jefferson, Marshall was a distant cousin of Jefferson, ended up posthumously related to one another through marriage over time. proving Jefferson's assertion correct on a metaphorical level. We are all Republicans, we are all Federalists. They note the unifying fabric for all Americans governed by law, our Constitution, and our judiciary, even as we disagree with one another. Something that is good to keep in mind after results of any election, because we are all passionate in our points of view. Thus, when we look in the rearview mirror of the early days of our republic, objects in the mirror are indeed closer than they may appear. Thank you again, Professor White, for guiding our discussion today. Thank you at home for listening to our conversation. We'll be posting some Supreme Court history book selections on our website, as well as a number of other selected readings related to our past and future programs. So take a look. We would like to hear from you with any and all questions, concerns, and program ideas for Politics Matters. You can email us at info@politicsmatters.org. We air Tuesday and Saturday at 8, as well as selected additional times during the weekdays. Thank you. Thank you again, Professor. And until our next meeting, I'm Jan Painter, and this is Politics Matters.